friends. At the outset, let me very warmly welcome Justice Ananga Patnaik, retired judge of the Supreme Court. Professor Faizan Mustafa would be joining us shortly. I just spoke to him. On behalf of the Beyond Binaries platform, I welcome all of you. Before I request Justice Patnaik to share his thoughts, let me set this context of this very important seminar on a very topical subject, which is basically making an assessment of the role of the courts, all kinds of courts, in stemming the rising tide of communalism in India. The famous historian Bipin Chandra defined communalism as a byproduct of socio-economic phenomena. He was of the view that when people try to combat socio-economic problems without knowing the real reasons, the canker of communalism spreads. For Assis Nandi, the social theorist, communalism came as a byproduct of secularism as the shadow delineating the limits of modernism. He was of the view that it is not the elite, but the poor and the middle class who bear the brunt of communalism. Dr. Radhakrishnan, in one of his most wonderful works, Recovery of Faith, in 1955, had observed that no one religion shall be given preferential status or unique distinction. Religious impartiality and forbearance have a prophetic role to play. He also said that no group of citizens should suffer any form of disability or discrimination because of his religion. Sunil Khilnani, an intrepid admirer of Nehru's inclusive vision of India, in his iconic book, Idea of India, had observed that the constitutional democracy has prevented monolithic outcome in India. He believes that it has stalled zealots in their tracks, penned demagogues in their quarrels, and taken wind out of popular cells. Democracy's singular and astonishing achievement has been to keep India united as a political space. And that space has become a vast marketplace whose strength lies in its internal diversity and dynamism. However, in a recent edit, the venerable liberal voice, Sri Gopal Krishna Gandhi, in an edit recently in the Hindu, has mentioned that the Hindu-Muslim dividing is growing into a new and menacing proportions and is belittling our constitution, debasing our greatness, and destroying our heritage of a shared peoplehood. At the inauguration of the Supreme Court, Mr. Motilal Sitalbad, our first Attorney General, had expressed the hope that, like all human institutions, the Supreme Court will earn reverence through truth. If one takes a long-term view of Supreme Court judgments as a check and balance against executive and legislative excesses, the ADM Jabalpur case in 1975, when the majority of judges agreed that the right to leave and liberty stand suspended during emergency, except this particular judgment, the most of the judgments have an edifying impact on the Indian polity. The lone dissenting voice in the Jabalpur case was Justice Hansraj Khanna, who said detention without trial is an anathema to all those who love personal liberty. Expanding further, he had said, neither life nor liberty are boundless, are bounties conferred by the state, nor did the Constitution create these rights. The importance of dissent in judicial decision was brought out by the highly respected Justice Ruth Bader Ginsburg of the US Supreme Court, the first Jewish woman to don the robes in the US Supreme Court. In the famous Bush versus Gore case, she has mentioned, she was in the minority judgment, she had observed that the confidence of men and women in the administration of judicial system is the true backbone of rule of law. Fali Nariman, in his book Before Memory Fades, writes that an impartial administration of law is like oxygen in the air. It is not enough for the judiciary to be independent of the executive. They must be seen to have noble quality of mind and heart, and above all, courage. And that courage of conviction was shown by Justice Khanna, who knew that he would be superseded to the post of Chief Justice of India for standing up to an absolute government. In an interesting edit today in the Times of India, titled The Missing Eye in India, Raghuram Rajan argues that the present tendency of group identity, like Hindu versus Muslim, Dalit versus Brahmin, Malayali versus Bengali, would need to be supplanted by natural rights of individuals. Basically, he's arguing that instead of community rights, the individual rights should be the leitmotif of a thriving democracy. Now, these are very utopic ideas where, as all of us know, there is a lot of positive discrimination. The identity politics is at play. So, therefore, we thought that instead of historians, social theorists, and economists reflecting on how communalism really pans out in India and how it can be contained, we should have in our midst a very venerable Supreme Court judge and a very redoubtable jurist, Professor Faizan Mustafa, to cogitate on these issues. In conclusion, let me mention that Professor Upendra Bakshi, the renowned jurist, had observed after the Kesavananda Bharati case in 1973 that the Supreme Court of India has become now the Supreme Court for Indians. The time for the court to arrest the canker of communalism and protect the poor and the vulnerable from the menace of communalism has truly come. And I'm extremely happy that this second seminar for the Beyond the Binaries series would be addressing this very important problem, and we'll have the benefit of the sagacious voice of Justice Patnaik and Professor Faizan Mustafa to share with the learned audience which have assembled today. Thank you very much. May I now request Professor Praveen Mahanti to briefly introduce Justice Ananga Patnaik, and I would request you, sir, to take the floor after that brief introduction. Over to you, Praveen.
Good evening, everyone, all present for this seminar. It is a great pleasure to introduce Justice Patnaik, who is agreed to address us all on this very important issue. Justice Patnaik got elevated to the Odisha High Court in 1994, and subsequently he has served on the Guwahati High Court, and later on became the Chief Justice of Chhattisgarh High Court and Madhya Pradesh High Court, till he got elevated to the Supreme Court in 2009. And he was a member of the Supreme Court till 2015 when he retired. Justice Patnaik is known for his bold decisions and is well regarded on his judgments on various important issues. So I will not take too much time and hand over the mic to Justice Patnaik. Thank you.
Welcome, Professor Faizan. Yes, sir.
Thank you so much.
Thank you. Thank you. Professor Mishra, Professor Mahanti, Professor Faizan Mustafa, Mr. Karthik Kishore, and all other who are listening to us in this webinar. I must first of all say that a very, very relevant topic has been picked up for discussion today, considering all that is happening in India now. But let me first of all give you a historical perspective. I don't know how many of you have studied the freedom struggle movement, the constitutional history of India. Historically, Hindus were there. Then Muslims, right up to the Mughals, they ruled this country. And you must have heard about a lot of conversion of Hindus into Muslims in those times. Sikhism was also there. And just coming. There were Sikhs in this country. Christians were there, a number of Christians increased when the Britishers ruled this country. Buddhists were there right from the beginning. So, India is a country of a number of religious communities. Now, in this background, when the constitution makers sat down to draft the Indian constitution, they thought of India as a multi-religious society. And they drew up a constitution which would be in the interests and which would safeguard the rights and interests of all religious communities, not just the majority community, religious community. Therefore, let me show those constitutional rights which have protected different persons practicing different religions and different religious communities. And these are all fundamental rights. To begin with, Article 25(1) of the Constitution, which clearly says that every person, when I read out this article 25, it says, subject to public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of chance and the right freely to profess, practice, and propagate religion. So any person, whether he is a Hindu or a Muslim or a Sikh or a Christian or a Buddhist or any other religion, he can practice his own religion, propagate it also. And this is a fundamental right, subject to public order, morality, and health, and to other provisions of the Constitution. It should be, the right has to be exercised subject to other. This is a fundamental right. Article 20. Then Article 26, which says subject to public order, morality, and health, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and removable property, and to administer such property in accordance with it. So therefore, a Hindu religious institution, a Muslim religious institution, a Christian religious institution, all these religious communities, they have a right to establish their own institutions and manage their affairs. This is also a fundamental right and protected by the Constitution. Article 27. No person shall be compelled to pay any taxes, the proceeds of which are specially appropriated in payment of expenses for the promotion or maintenance of any particular religion or denomination. That means government cannot pay any taxes. Taxes is a compulsory exaction. Nobody can refuse to pay taxes. It's not a voluntary contribution. So no person in India can be subjected to a tax, the proceeds of which will be spent for some religious purposes. See the nature. Now, 28. No religious instruction shall be provided in any education institution, only maintained out of state funds. So, if an institution is being maintained wholly out of state funds, not anything, wholly out of state funds, then no religious instruction can be. So, these are nothing clause 1 shall apply to any education institution which is administered by the state, but has established under the endowment of trust, which requires that religious instruction shall be imparted in such institution. Right. So the entire idea is the state or a state-run education institution will not impart any religious instruction. Whether it's what we call Hindu religious instruction. I remember when I was in school, I studied in Nalsar College, right? It's a private institution. Right from class 7, I was in residential school, right from class 7. When I joined there, 1957, all the afternoon classes were devoted to Mahabharata and Ramayana. Ramayana and then Mahabharata. And I was only 7 years old. And we learned there. And Hindus, all Hindus, they have to go to the temple. They have to go to the temple. Muslims may go to the mosque. We didn't have a mosque in the school. We had temples. So religious instructions were being given in the private institution. But a state institution cannot make this compulsory. And we cannot also provide for this system. Now, Article 29, any section of citizens residing in the territory of India or any part thereof, having a distinct language, script, culture of its own, shall have the right to conserve the same, and no citizen shall be denied admission to any education institution maintained by the state or receiving aid out of funds on grounds only of religion. Other grounds are there, race. So, state institution cannot say, yeah, this is a government college, all right, or the government school. A Muslim cannot be admitted here, or Christian cannot be admitted here, or a Buddhist cannot be admitted here, or a Hindu cannot be admitted. It is open to all. Article 30. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Right? So these are the provisions in the Constitution. And because these provisions in the Constitution, Supreme Court has held that this is a secular state. Indian Constitution is a secular constitution. In other words, the state is not supposed to favor any particular religion. It is not to favor also the majority religion. And in the preamble of the Constitution, it was amended and later on introduced. Because the people constituted India into a sovereign, socialist, secular, democratic republic. The word secular was added later on. Right? It was because the provisions were already obvious that it was a secular country, secular state, secular constitution. And the Supreme Court later on, after Kesav the Martin case onwards, when they laid down the basic feature of the Constitution, the basic structure of the Constitution, cannot be altered, cannot be amended, even by Parliament. There are basic features, number of basic structures, basic features, democracy, parliamentary democracy, federalism, and one of them is secularism. Secularism is a basic feature of the Constitution of India. This has been held in Kesav Bharati, the state of Kerala, 1974 SCC, 2 through 5, when the basic feature or basic structure theory was introduced for the first time, Supreme Court 1917, when the Supreme Court said, Parliament can amend any part of the Constitution, or amendment provisions and the 68 can apply to any part of the Constitution, except they cannot destroy the basic feature. Then one of them is secularism. So remember, in India, secularism is a basic feature of it. Then we also held this has also been held in S.R. Bommai, President of India, 1994, 3 SEC, 1. Aruna Roy was President of India, 2002, 7 SEC, 368. Then prior to that, very important case, Dr. M. Ismail Faruqi and others, President. And I have also quoted this in Pramati, actually when Article 15 was amended. 15A was not to be challenged. In the Constitutional bench, I said, this is a basic feature nobody can touch. Right? Even this Parliament cannot touch. If it touches, it will be struck down by the, so it has to be struck down. Unless they change the basic theory system, basic structure. 13 judges of the Supreme Court have already now held, and thereafter many judges have followed, that basic feature includes, of the Constitution includes secularism. This cannot be touched by any. Now, if this be so, against which power are these fundamental rights guaranteed? They are guaranteed to the people, to the communities in India. They are Article 25, Article 26, Article 27, Article 22, Article 31, right? Against whom it is guaranteed? The answer is, it is guaranteed against the state. And which is the state? State has been defined in Article 12 of the Constitution to include the Government of India and Parliament of India, Government of each state and the legislature of each state, municipal authorities, other authorities, all other authorities in the territory of India, and all of the other government. And who's to protect them? Who's to protect them? The judiciary. I'll come to that later. So basically, the rights, religious rights, to ensure that everyone, every religious community, every religious person, no matter which religion practices, is safe and protected, is guaranteed by the Constitution. This is a basic feature of the Constitution. And it is guaranteed against whom? The state. State means the government and parliament of India, government of each state and nation of each state, municipal authorities, other authorities. Look at the foresight of the Constitution makers. Look at the foresight of the Constitution, what they thought. Parliament encroach on these rights. I'll give you an example. Right. And they thought Government of India may encroach on this. And Government of India means whom? So far as Delhi is concerned, police is under the Government of India. So far as states are concerned, all states, it is guaranteed against state governments, and police is under the state governments. They have to be, people have to be protected against them. And who will enforce it? I'll come to it in the courts. Or I'm giving on the courts under Article 221, the High Court, under Article 32, Supreme Court, and of course, the subordinate courts. I'll come to that, how they have to enforce. So, first of all, I am impressing upon all of you the important point that the guarantee of these fundamental rights, which make our country secular, is against the legislatures, the parliament, these central government, the state governments, Municipal authorities, all authorities, we include the police. And we enforce it, the judiciary. Right? And how does the enforcement come in? Now, you see, it is not as if this communism was not widespread before independence. It is not as if it is happening today. It was happening in pre-British, pre-independence era. You know that. And that is why these provisions have been made to protect independent community. I'll give you an example. If you read the provisions of the Indian Penal Code, 505, Indian Penal Code, section 505, 2, it says, whosoever makes, publishes, circulates any statement or report containing a rumor, alarming news with intent to create or promote, which is likely to create or promote on grounds of religion, race, place of birth, right? Race, place of birth, residence, language, caste, community, or any other grounds, right? So, grounds of religion is also there. You can't make a statement toward the sentiment of the what we call a different religious community. If you do that, you are liable for being tried and punished for 3 years with fine. Then 505(3), which says whoever commits an offense specified subsequently in any place of worship or an assembly engaged in the performance of religious worship or this ceremony shall be punished with imprisonment which may extend to 5 years and shall also be liable to. So therefore, Indian Penal Code provided way back, long back in 1898, this provision was introduced to the Indian Penal Code. The Britishers thought that India is a place where religious sentiments are very important. They cannot be hurt, and if somebody hurts, it should be punished. It will lead to a lot of public chaos and law and order. In the Indian Penal Code, the Britishers itself provided for it. Now, after the Constitution came into force and democracy was introduced, elections were brought in. In a parliament, the Constitution left in Parliament to make a law, how elections will be conducted. And the Repetition of People Act 1951 provided in section 125 something called electoral offences. While election, what somebody should not do. And 125 says any person who in connection with an election under this act promotes or attempts to promote on grounds of religion, race, caste, community, or language, feelings of enmity or hatred between different classes of citizens of India shall be punished with imprisonment for a term which may extend 3 years or with fine. So it is also provided as an elected offence. Why? Because somebody will try to take votes, come to power by appealing to religious sentiments and by ensuring get it to another government. So all these provisions were there in the. Why? Because they know all this is happening. It is not as if it's a new phenomenon. It has been happening right from the British days. In fact, India-Pakistan was divided only because of this. Right? These religious sentiments were already creating a lot of problems. So these are the provisions of law. Then if you come to the Indian democracy, what happens? If you look at the history of the riots, 1984 riots against Sikhs in Delhi. It was triggered by what? Assassination of Indira Gandhi, 31st October 1984, by 2 Sikh guards. 1 Sikh guard or 2 Sikh guards. Maybe. Now the riots broke off against whom? The Sikhs. And the police looked the other way. I was here when I was in Delhi on that day. I know what happened in Delhi. I had come to practice in Supreme Court, appear in Supreme Court, and next day I left for Bhubaneswar. I was practicing in Patnaik. And I've seen what was happening. Police was looking the other way. and 6 were being slaughtered. Their houses were being burnt. They were being pulled out from buses. Their beards being pulled out. Police was supposed to protect. Why did not protect? I leave you to guess why they could not protect. But much later they suffered. But police did not protect. And I leave you to guess who was in government then, why they could not protect in Delhi. 2002, this was triggered by the Godhra train accident in the fire, in which about 58 Hindus were burned. For water, maybe. Then the attack started on the Muslims in Gujarat. Police was supposed to protect them. Why did they not protect? Why did they not protect? And the riots went on almost 1 year. This happened on 27/2/2022, Gujarat incident, followed by Gujarat. You see this? It was the duty of the state to protect under the Constitution. Right? But it did not. Then third, of recent Citizenship Amendment Act, enacted in December 2019, and then the Delhi riots took place in 2020. Delhi riots. Right? But these acts, this was an act made by this parliament. Right? But who was to protect this? Again, the police was supposed to protect. I have gone and visited the Delhi riots place in 2020. I have seen the area. One community houses were totally burnt. Totally burnt. And there were Hindus and Muslims staying side by side. They were living on very peaceful. They are living very peaceful, but so badly. Whose duty it was to protect? The police was to ensure that. Right? And thank God, in this Hanuman Jayanti incident, the moment they stole pelting, this is in 16th April 2022 on Hanuman Jayanti day. The moment it started, the police intervened and stopped it. Otherwise, it had gone to what that you can't imagine. Then, unfortunately, devolution started, the court sent. So, I would say that in India, it all depends how the state government and central government use power over the police, and also have got investigating powers to the police control this. Unless that is done, I remember when the Kandhamal riots broke off in Orissa, right? And that was again the Christian Panos and Hindus, they fought. Right? Police is supposed to protect them. Nobody else. State is supposed to protect them. Nobody else. But when the state fails in this constitutional duty, it's the job of the courts to come. This is what I am saying. This is bound to happen. Because when number of communities are living in one area, it's bound to happen. Likely to happen. Because of the religious sentiments are there. Very difficult, as Professor Mishra said. There are idols and philosophies. Hindus, Muslims must live peacefully, that thing. Human beings are human beings. They are fanatic religiously also, some of them. Very few are tolerant. You can't live on idealism. But when it happens, the state's duty to do it. If states fail, it's the job of the courts to do it. This is the point I make. I give you some examples, and I'll conclude with this. Now, first of all, I'll say the courts have to be very careful and very sensitive. Why? Because the state is failing. State is failing. And the slightest chance, because of Article 226, the High Court should intervene. Because of Article 32, the Supreme Court must intervene. And lower courts, very difficult, they intervene at a later stage. What the lower courts have to do is very carefully frame charges when riots took place, ensure that police has not been biased in framing charges. Very carefully, allow the person who is arrested to remain inside. Must look at the papers very carefully and see whether the arrest has been because of religious bias. Then in trials, they have to be very carefully. See, anybody, whichever religion he may belong to, if he commits an offense, he has to be tried and convicted. Otherwise, law and order, whichever religion it is. Courts have to be very careful. I'll give you just 2 examples in which I have been a particular. One is the Akshardham case which came from Gujarat. In Gujarat, after the Akshardham terrorists entered the Akshardham temple and they started shooting, and then ultimately the terrorists were shot down. Right, all the terrorists were entered and were shot. Later on, an FIR was filed to find out who are the conspirators outside the temple, apart from the terrorists. And after 1 year, they applied the Quota Act, when they could not the Quota Act. And investigation was taken over by the state crime, special crime branch. And 11 Muslims were out. The trial court convicted them and asked them 3 of them for death sentence. The High Court confirmed the death sentence and upheld the conviction. When it came before us, we found there was absolutely no evidence against the 11 persons. And the main evidence was confession recorded under the Quota Act by Mr. Banzara, the police officer, recording confession of guilt, and that strength, they were all convicted, and 3 of them put to death. We found nothing in it. And in the Supreme Court, Mrs. Goda and I, we acquitted all 11 of them. Why? Because we were convinced that these 11 Muslims in the minority community should not be made to suffer if they have not committed offense. Acquitted all. Right. All 11 were acquitted. This is one case. Right. So the courts have, in my opinion, the trial court should have been more sensitive. The High Court should have been more sensitive. And why they had to wait till Supreme Court to get the acquittal? Right, but we had to do it. Second case is the American Center where they were shooting in American Center by some terrorists, some Muslims. Right. And I had a judge colleague with me, this is Khalifa, Muslim judge. He said, I told Justice Khalifullah, you are going to write this judgment. And you have to find out whether these persons are guilty or not. They are all Muslims. Main person who had shot, he had been killed in an encounter already. And he held they were all guilty. They were all involved in the conspiracy. Right. There were materials also when they were being financed from Dubai. Right. And Justice Khalifullah held them guilty. But we decided there is no question of death penalty. Death penalty had been given to all. I said, we can't give death penalty because they are conspirators. The main person who was killed, he's already dead. And the guilt was upheld. All Muslims. So, you see, as Professor Mishra was saying, that judges, we found, they go to the courts, judges are to be very sensitive. And they must realize that secularism is a basic feature. They must realize that we must protect the minorities for unfair trial, for unfair action. And this we could do in the Supreme Court, two of us, with four of us. Many other cases also they do it, right? Because we had commitment to secularism.
Absolutely.
Unless judges have commitment to secularism, they can't do it. If they start thinking what will the mayor become think, what will the public will think, what that will think, what the government will think, what the ruling party will think, then they cannot do justice. Independence of judges means independence also in the values enshrined in the constitution, namely secularism. You must protect the rights. This is how we can save the country, and we expect that judiciary has to intervene at right stage to save ensure that communism, rising trend of communism is arrested. Thank you.
Thank you very much, sir, for your very, very candid comments. May I now request Professor Faizan Mustafa to share his thoughts. It's with great pride I must mention that Professor Faizan was my director in the School of Law before he went to the National Law University, Cuttack, and presently he's the Vice Chancellor of Nalsar. But besides being the Vice Chancellor, he has assumed a larger role now, familiarizing people with the nuances of law in simple Hindustani. So may I now request my dear friend and a very valued colleague, Professor Faizan, to share his thoughts. Over to you. Thank you, sir, very much.
Thank you so much, Mishra sir, my Lord Justice A.K. Patnaik, my colleagues from KIT Law School. Odisha is my second home. I go to Odisha more often than Aligarh, and the kind of love and affection I have received from Odisha people is unbelievable. I am now in Hyderabad for 10 years, but I have not the same kind of relationship which I have in Odisha, right from the top to the bottom. And just to give you an example, since we are going to talk of communalism, when I was at KIT Law School, all my colleagues used to fast with me, and we used to break our fast together. And that is what syncretic Indian tradition is all about. My Lord has already explained to you the law in the Indian Constitution and in the Indian Penal Code. He talked about his landmark judgment in Akshay Dham, which clearly shows that in many terror-related cases, false charges are leveled, and unless you have a sensitive judge like Justice Patnaik, conviction and award of death sentence is to be expected. Now, this evening, since His Lordship referred to the glorious history of India, I would like to also go back for a minute to our history. Both Islam and Christianity came to India quite early, and both were able to get integrated with people living here, and that shows the inherent greatness of world's most tolerant religion, Hinduism, and the whole question that they never felt that as if they were foreigners or aliens. Lot of myths have been created to distort history, and history writing contributes to communalism. So the initial interaction of Islam was not on the western side of India from where invaders came, but on the Malabar coast and in the life of the Prophet himself. And the Prophet is reported to have said कि हिंदुस्तान से मुझे वफा की बू आती है. I smell loyalty from India. And when he is saying loyalty from India, he is not talking of Muslims, because Muslims have just arrived. They are a minuscule minority. And even Al-Baruni, when he refers to Indian Muslims who came with Mahmud Ghaznavi, he calls Indian Muslims as Hinduized Muslims. And if this word Hindu is to be given a geographical connotation, then I have little hesitation in saying that all of us are Hindus, including Indian Muslims. But some facts of history which we are systematically trying to erase, to create in minds a feeling of, threat and exploitation and preparing people to take revenge for the historical wrongs. I think it is necessary that I spend a minute on it. So in 712, when Sindh was conquered, the Arabs, treated local Hindus as people of the book. In Islam, they treat people who follow Abrahamic religions as people of the book. And people of the book are not kafirs. People of the book are not disbelievers. They are not unbelievers. To be a kafir means you don't believe. So kafir is one who challenges. And kafir in the Urdu poetry is also used for the beloved. So you also at times tell your beloved, badi kafir adaएं हैं तुम्हारी, like this. So a person will address his beloved like this. So there are gold coins, 2 gold coins available to us, issued by the first Arab conquest, so to say. One is seated Lakshmi, both are bilingual coins. The other has Shiva's bull. Now, pictorial representation as such, if you go by Islamic theory, is prohibited. And this tradition continued during the entire Delhi Sultanate. You will have Firoz Tughlaq renovating the Mahabodhi temple, and his name is still inscribed there, that the renovation was undertaken by Firoz Tughlaq. Nizamuddin was a Sufi saint. One day he was walking on the bank of river Yamuna in Delhi, and some Hindu women were doing Surya Namaskar. Now, Islam believes in oneness of God and does not treat sun to be sacred. But here is Nizamuddin telling Amir Khusro, these people are doing ibadat-e ilahi. They are doing the worship of Allah. And when one disciple brings another brother of him, saying that you convert him to Islam, Nizamuddin refuses it. When Babur came to India, the entire revenue administration was dominated by Khatris. And of course, the Muslim fundamentalists, the ulema class, did not like it. So one Maulana Sheikh Abdul Quddus Gangohi wrote a letter to Babur, which is available, that entire revenue administration is dominated by Khatris during the Delhi Sultanate. You don't give that much of prominence to Khatris, you take Muslims. This is how the fundamentalists on both sides, react. Of course, about the Mughal rule, I have been saying that it was a Mughal Rajput rule. Most of the Indian Muslims cannot be blamed what Mughals did, because they were not a party to rule. An elite was ruling. The Pasmanda people, the poor people, the illiterate people, the larger masses, the peasants were not ruling. So hardly Mughals were about 3 to 4%. Otherwise, 95% of Muslims were local converted Muslims. Most of the mothers of great Mughal kings were Hindus. In the bureaucracy, in the nobility, and in army, you had about 32 to 38% Rajputs and Hindus. Look at Battle of Haldi Ghati. Akbar is not there. In the famous battle with Maharana Pratap, Mughal forces are led by Raja Man Singh. And in Maharana Pratap's forces, you have several Muslims fighting for him. Recently, RSS chief Mohan Bhagwat ji himself referred to Battle of Haldi Ghati and saying that, well, Hindus were fighting on the side of Mughals and Muslims were fighting on the side of Maharana Pratap. Therefore, the history is not like this Hindu-Muslim history the way we are presenting it today. I also believe that this whole question of communalism has something to do with British. And what British did to us has recently again been referred to by RSS chief, but it is important. Prior to British, the identity was local. The identity was caste-based. So if at all some people come together, let us say the landlords come together, so Hindus and Muslims, both landlords will come together against the peasants. But there was no national identity. The British through census gave us identity, and that led to the identity politics. And as a result of identity politics, we got communalism. Just let me explain to you in a minute. So what really happened, that British treated that all Hindus are homogeneous and all Muslims are homogeneous. Now this is absolute negation of the reality of our society. There are Muslims, groups of Muslims, who still believe in the 10 incarnations of Vishnu. There are still groups of Muslims which are governed by the Shastric Hindu law, unreformed Hindu law. There are Muslims who still follow the co-parsonary system. The entire Malabar Mopila Muslims were more influenced by the Hindu law and following the Hindu traditions. And my Lord is aware of series of cases we have about Khoja Muslims, Bohra Muslims, Mopila Muslims, even in Kashmir. Kashmiri Muslims were not following the Muslim personal law. The Muslim personal law which we were following in UP or in Odisha was not there. In Muslim law, adoption is not there, but Kashmiris were having the adoption under the Shri Pratap Consolidation Act of 1934. Muslims don't make a distinction between a married daughter and an unmarried daughter, but the Kashmiri law made a distinction between Dokhtare Khana Nasheen, married daughter living with father getting a higher share in property, and married daughter living with husband getting a lower share. So British, through these caste and religious affiliations that got reflected in the official records, permanently categorized the religious identities of individuals. And this, in my opinion, fueled communalization by eliminating the earlier distribution of power. So since the Hindu education renaissance under Raja Ram Mohan Roy came 50 years prior to Sir Syed Ahmad's illegal renaissance, so Hindus were educated, Hindus got the government jobs. This created a kind of fear in the minds of Muslims that now Hindus are going to dominate us. Therefore, some prominent Muslims, which were encouraged again by the British, met the Governor General in Shimla, gave a memorandum and said that you protect our rights. And there is a diary available of someone who was working in the Viceroy's house. And in that diary, it is clearly written that today's day is a very important day because we have taken away huge masses out of the national movement. And we have created the seeds of division, partition, and communalism. And this is all recorded. I have quoted it in one of my articles. So what has really happened, that the British, to create this division, conceded and gave what is called separate electorates. Well, there will be elections, but Muslims will vote for Muslims, Hindus will vote for Hindus. And this separate electorate and this identity politics eventually led to the unfortunate partition of the country. And the shadow of the partition looms large on us. Of course, larger Muslim masses, just like the Mughal rule, were not a party to partition because they never voted in it. The voting was under the Government of India Act 1935. And under the Government of India Act 1935, right to vote was extremely restricted. You can check it and Google it and find it out. Only an educated person, a person who has a land, a person who was paying income tax had a right to vote. So only about 3% Muslims had a right to vote under the Government of India. And therefore they did not ask for partition or endorse the partition. And the other evidence is, once the partition happened, massive majority of Muslims refused to go to Pakistan. They preferred to stay back. I met one gentleman who I was told was, every Friday participating in the Muslim League rallies. I asked him, Chacha, aap Pakistan kyun nahi gaye? And the man with the pain in his eyes told me, Hamara to बेवकूफ बना दिया गया. मैंने कहा, what do you mean? How are you made fool? हमें तो ये बताया गया कि अंग्रेज यहां से जाएं ताकि देश पाक हो. Pakistan means Pak. We thought this British have polluted our country. I never thought that we have to go to some other country. We wanted to free the country from the pollution of the British. And therefore, I thought India is going to become Pakistan. Once British are... So there were so many people who really did not understand the whole logic of the partition and the two-nation theory initially given by Savarkar and then subsequently also adopted by Jinnah led to that great human tragedy in which millions of lives were lost. And then there have been communal riots after riots to which a reference was made by my lord. I am just going to tell you one paragraph because my brief today is to look at how judiciary is not arresting this ugly tide of communalism. This is from Gujarat, to which my lord had made a reference. On the 5th day of the burning of train in Godhra, where 59 car sevaks were charred to death, Gujarat broke out in a communal frenzy. Bilqis Bano and her family of 17 hid in a truck and traveled to move to a safer place. When the truck reached the Randhikpur village in Dhaur, not far from Ahmedabad, a group close to 35 to 40 rioters stopped the truck. In a span of an hour, swords spilled blood as each and every member of her family was on the ground. Heads mutilated, bodies ripped apart by fanatical swords. One of the attackers smashed her 3-year-old daughter Saliha's head on a rock and killed her on the spot as Bilqis stared at the sight, closing her eyes while another group of men ripped off her clothes. Bilqis pleaded with them, kept repeating in Gujarati that she was 5 months pregnant, but that did not deter the men who wanted to protect Hindu pride by violating Muslim women. One by one, the men took turns to rape a pregnant Bilqis Banu, who stared numb at the sky. They kept attacking her with their knives. Her body had slits all over. Her cousin, who had delivered a baby 2 days ago, did not escape the savagery of the man who kept raping and finally killed her. The men kept violating her while another man slit her mother's throat. This is how communalism makes us inhuman and subhuman. And the similar thing one is watching. People are celebrating bulldozing of jhuggis, bulldozing of people's small shops through which they are earning their livelihood. And that's why I say, as Cohen has said, that one may not understand what is justice, but the best way to understand justice is to get a sense of injustice. Today we are losing this sense of injustice, and therefore my worry is that probably we are becoming not a Hindu, not a Muslim, but we are not, or we may not remain even as a human being, because empathy is an essential trait of every human being. We Indians are losing empathy. We celebrate in somebody else's humiliation. This is absolutely against Indian culture. It took 17 years for Bilqis, from 2002 to 2019, when finally the Supreme Court gave 50 lakh compensation to her. The record of our courts in terms of arresting the communal voyeurs is a mixed one. In another case, again from Gujarat, where the famous Best Bakery case, where a mob has set fire to Best Bakery on March 1, 2002 in Vadodara and killed 14 people, the witness Zahira Sher was fighting a battle parallel to Bilqis Bano. And again, Supreme Court made an observation, modern day Nehrus who are looking elsewhere when Best Bakery and innocent children and helpless women were burning, and were probably deliberating how the perpetrators of crimes can be protected. What I am trying to say, that if you look at Gujarat, then the record of the judiciary is not that bad, because unlike other communal riots where nobody had been convicted and nobody has really been punished, in Gujarat many people, including policemen, have been tried, have been punished, and have been sentenced, including a minister. It is a different story that in last 2 years, many of these people who are involved in massacre were given the bail by the Supreme Court so that they will do some social service. While people who are social activists, they are not getting the habeas corpus petitions even listed, and therefore there is that kind of disparity. What I am trying to say, that this whole question, if we want to look at and how courts have really looked at the question of communalism, to be fair to the court, I would say, Mishra Saab, court doesn't have the burden to combat communalism. My lord rightly said it is the duty of the state. If we want to contain the virus of communalism, then court is the wrong forum. It is the duty of the political class. It is the duty of the media. It is the duty of the civic society. It is the duty of the larger society, and it is the duty of the religions. Because there will not be a lasting peace in the world unless and until there is peace between and within religions. Within religions also it is important. Look at the fight we had between Shivites and Vaishnavites. Look how in Pakistan, Sunnis are massacring Shias who are praying in mosques. Look in Sudan, in Iraq, in Syria, in Afghanistan, how one Muslim group is killing another Muslim group. So not only we need peace between religions, we need peace within religions. Now, there are cases which I think are problematic. Sarla Mudgal is one judgment which I think borrowed the narrative which encourages communalism. The narrative is like this, that you come up in a judgment words like true Indian, un-Hindu, true Muslim. Therefore, there is in such paragraphs a kind of settled segregation that there are people in our society who are not fully committed to our nation. And this segregation not only substantiates the Hindu rights theory, but it also leads to communalism. What were the facts? 4 Hindus, Hindu men, converted to Islam to take a second wife without divorcing their Hindu wife. In an ideal situation, the judges should have come down heavily on these Hindus. Why you converted and why you took a second wife? Rather than doing this, Sarla Mudgal blames Islam. Sarla Mudgal blames Muslims rather than blaming these Hindu husbands who have taken a second wife. And the kind of statements which have come from concurring judgment in Sarla Mudgal are really shocking. This is how it goes. The court noted that the state reforms of Hindu, Buddhist, Jain, and Christian personal laws showed that these groups had forsaken their sentiment for the cause of national unity, while other communities had not done so. Look at this sentence. You are trying to say that these communities who have taken the reforms, they are contributing to the national unity, they are pro-nation, and others are anti-nation. This is not the correct story. Look at the Hindu Code Bill. When the Hindu Code Bill was introduced in Lok Sabha with Ambedkar as law minister, out of 27 ministers, out of 27 speakers, 24 opposed it, including the Congress president, including the leader of the house. Rajendra Prasad, who was the president, said that if Hindu Code Bill is presented to me, I will veto it. RSS led a campaign. 1952 election, Nehru had to fight on the question of Hindu Code Bill. Gita Press was publishing a magazine called Kalyan, where article after articles were written against the reform. So much so that even it was said that unlimited polygamy is good. Here we are trying to say, I would say that the fault lies with Nehru. He should have reformed all personal laws in one go. It would have been much easier. What Nehru did not do, for that you can't be blaming an entire community to say that those who are continuing with personal laws, they are not contributing to the national unity. I think this argument is absolutely flawed. In addition, the court implicitly distinguished between true Indians and those who engage in religious practices which deviated from rituals of the majority, those who preferred to remain in India after partition. This is Supreme Court saying, those who preferred to remain in India after partition of India fully knew that Indian leaders did not believe in two-nation or three-nation theory, and that in Indian Republic there was to be only one nation, the Indian nation, and no community can claim to remain a separate entity on the basis of religion. Historically, it is wrong. When the partition resolution was debated in the Congress Working Committee, Gandhiji voted for it, Nehru voted for it, Patel voted for it, Maulana Azad did not vote for it. On the day this resolution was taken, in the morning Maulana Azad met Gandhiji and said that only you can stop partition now. And Gandhiji had said partition would be on my dead body. In the evening, Gandhiji voted for partition. The two-nation theory, even before Jinnah, was talked about by Savarkar. Look at the chronology. If at all chronology is important, look at year to year. My point is that to say that those who have stayed in India, they have stayed in India, they also don't believe in two-nation theory. Legal pluralism is a recognized tradition world over. I have been writing that it is not necessary you should have one law. Uniformity of law is not important. Justness of law is important. Even Hindu Code Bill is not one act. You have Hindu Marriage Act, you have Hindu Succession Act, Hindu Adoption and Maintenance Act. Why this bifurcation had to be done? Because Hindu right criticized Ambedkar and said Ambedkar is taking the revenge from the upper caste. Ambedkar had to resign, Nehru had to compromise, provisions were diluted. Hindu daughters could not become a co-parsoner before 2005. So many concessions had to be conceded. Law reform process is a time-consuming process. I am not at all justifying continuance of different personal laws. Definitely, we may have legal pluralism, but every personal law must be tested on the touchstone of the Constitution. Every law must be gender just. But you can't be blaming any community for not having uniform civil code. The directive in Article 44 is not to the community, is to the state. State shall endeavor. I am not the state. Where is the endeavor? Where is the blueprint? We could come up with Hindu Code Bill because in 1941 we constituted a Hindu Code Bill committee. From 41 till 55, we debated what we will include, what we will not include. Which government has constituted a uniform civil code committee or a committee like Hindu Code Bill Committee for Muslim law? Recently, when the Uttarakhand Chief Minister on the last day of campaigning said Uttarakhand will constitute a committee, I wrote an article in his favor. I said, yes, that is the right thing. First, constitute a committee. If we need to have a uniform civil code, even we have to go back to Hindus, because there are many provisions of Hindu law which may also need a reform. Because in Hindu code, because in uniform civil code, you need to borrow good provisions of various laws. So I believe that Sarla Mudgal, instead of indulging in this kind of thing, should have said that there is a growing menace of conversion for taking a second wife. This we cannot permit, as my lord rightly said. Very opening words of Article 25 are subject to public order, health and morality. And therefore we should have said that these people are wrong and these marriages are illegal, full stop. But if you leave Sarla Mudgal is contributing to a particular narrative. And I think no discussion can be complete about communalism if I do not refer to Hindutva judgment. Because Hindutva judgment validated a particular narrative. What was the case about? There were provocative speeches in the name of religion. Some of these speeches, the court itself found that they are in violation of Representation of People's Act. But a speech by Manohar Joshi, where he said, if Shiv Sena is voted to power, Maharashtra will be the first Hindu state. Supreme Court is saying that it is not an appeal in the name of religion. The court quoted earlier judgments where there was a discussion that Hindu religion does not have one book, does not have one God, does not have one method of worship. it cannot be precisely defined to say, well, Hindutva is a way of life. Now, using Hindutva and Hinduism interchangeably is the problem. In the two earlier judgments, to which the reference was made by Justice J.S. Verma, I think nowhere word Hindutva has been used. They are talking of Hinduism. They are not talking of Hindu. Hindutva has a context. Even V.D. Savarkar in his book, Who is a Hindu, makes a distinction between Hindutva and Hinduism. There is a political context to it. That context cannot be ignored. And therefore, the legitimacy to a kind of rightist politics, which was done by a particular group, was given by the Supreme Court. And in 2017, in the Abhiram Singh, when Supreme Court's 7-judge bench had an opportunity to revisit this judgment, they refused to do it. My Lord Justice J.S. Verma himself was apologetic about the judgment. And he said, this was not what I really meant. Of course, Hinduism is most liberal, most tolerant. But Hindutva and Hinduism are not synonymous. One is acceptable to everybody. About others, there are very serious reservations even amongst the Hindus. And those differences cannot be ignored. And finally, I would like to refer to the whole Babri Masjid case. In the Babri Masjid case, when Rath Yatras was there, 100 cities in the country were under curfew. There were requests to ban it. The judiciary did not come forward. When the Car Seva was going to take place on 6 December 1992, people did go to the Supreme Court and did tell that there are weapons, that there are construction material. Supreme Court decided to go by Kalyan Singh's affidavit. And as a result, a only surviving piece of Sharqi architecture was brought down. Yes, temples have been demolished in history, mosques have been demolished, churches have been demolished, and all such demolitions must be condemned in the strongest possible terms. But those demolitions did not happen in rule of law country. They did not happen when democracy was in place. And what my Lord rightly said, secularism was the basic structure. Everyone saw on BBC how this mosque was brought down. And in 2019, Supreme Court itself said that placing idols in 1949 was egregious wrong. Demolition was egregious wrong. But then, if you look at all the status quo orders, and they are not 1 and 2, but more than a dozen, they did not try to arrest the tide of communalism. Those orders are problematic on pure legal grounds. After 1992 demolition, what has happened was interesting. That from 1949 till 1992, as you know, no one was allowed to worship. Idols were put in 1949. Every day, worship of God was done in the morning and in the evening, but public was not allowed. In 1986, there was an order by the district court and the doors were open. Now, after 1992, ideally there should not have been any worship. But then Allahabad High Court allowed worship. And then they also interestingly in that order said Lord Rama is a constitutional figure, because in the original copy of the constitution, you know that there are sketches and paintings which were made to decorate the original copy. By that logic, Akbar is also a constitutional figure. Emperor Ashoka is also a constitutional figure. If we are a secular country, how can any religious figure can be a constitutional figure? In fact, if you go to our Constituent Assembly, 66 constitutions in the world, in their preamble, start in the name of God. So there was a proposal that we should also start the preamble of our constitution in the name of God. So the initial opposition was from Bengal, where Bengali people said, no, we need to start it in the name of goddess. We believe in Ma Durga. Then the saner element said, don't do this. Mr. Kamath was persuaded to withdraw the amendment. He refused to withdraw the amendment. Harcourt Butler has written about us that Indians are essentially religious, as Europeans are essentially secular. In a deeply religious country, allow me to, Mishra Saab, to tell your audience, God was put to vote in our Constituent Assembly, and thank God, God lost it. So through a vote, we removed God from our Constituent Assembly. But thereafter, religion has occupied a central place. Mixing of religion and politics is the much greater problem than the problem of communalism. And therefore, I would say that we can't be blaming courts for communalism. We can't be saying that the court did not effectively combat it, because that forum is adjudicatory forum. That forum cannot solve social problems. I have been writing on this, that the courts are ill-equipped to reform religions. They are ill-equipped to reform society. The reform, social reforms must come from the state, from the society, from the NGOs, and from the media. Therefore, this is the time when we must, if we want to make India as a strong country, then all this communal hatred must go. As a strong and united nation, we should move forward. Unlike the Germany of 1930s, where you had Jews only 0.75%, not even 1% Jews were there. You have 14% Muslims. This Muslim question, you cannot give them the same treatment which was given to Jews. And therefore, dialogue, conciliation, better Hindu-Muslim relationship, creating a trust is necessary. What the Prime Minister of India has been saying, Sabka Saath, Sabka Vikas, Sabka Vishwas, is the only way out. There is no other way out. We have to win over the confidence of the minorities. We have to tell them that they are an equal citizen of this country. Then only we would be able to solve the problem of communalism. Nehruji is on record. Minority communalism is bad, but majority communalism is worse. Thank you very much.
Thank you. I thought I'll just mention to all of you that Professor Faizan was a little reluctant to speak because he is doing Rosa. So if with Rosa he has been so passionate, I'm not sure how it would have been without Rosa. So I think it was an Indian speaking. And thank you very much, sir, for your most candid and most wonderful views. Praveen, could you kindly conduct the Q&A session?
Yeah. Before we take on questions from the audience, there are a couple of questions on the chat. First question is, will this uniform civil code not help douse the flame of communalism and even casteism? Professor Mustafa, would you like to take that question?
No, I'll request Prof. Justice Patnaik to take that.
Okay.
See, as Professor Mustafa rightly said, that uniform civil code does not mean that you make all personal laws uniform. Personal laws are very difficult to touch. The country will flare up. You saw what happened in the Citizen Amendment Act. It was not affecting personal laws. It was affecting only citizenship. But how much of agitation took place? Right? So, on the one hand, you have Article 25, right to practice in a religion, 26, 27, 28, 29, 50. On the other hand, you have uniforms. Right. But as again Professor Mustafa rightly said, that you see the personal laws. If there are any problems of personal law which are affecting rights, particularly of women, for example, triple talaq case, the Supreme Court struck down. So the triple talaq cannot be maintained. 3 judges out of 5 judges said no. The triple talaq is illegal. The same thing could have been done by the legislature. The legislature was avoiding it. Why it was avoiding it? Because again, there are a lot of problems become. There will be fair ups. When the judiciary did it, I strictly don't agree with the reasoning given there by the judiciary. But I mean more powerful reasoning. But if there are some problems in some personal laws, please remove it. Right? Hindu Marriage Act. Some problems, remove it. Succession in the Succession Act. Some problems, remove it. Make it in favor of the woman. See, the country is changing, country is advancing. With advancement, your thinking is changing. And as Professor Mustafa said, we are all going for legal pluralism. Legal pluralism means all kinds of religion also must function in their own ways. But where there are problems affecting public order, affecting morality, affecting all that, please go in and make some law so that the rights of women are protected in the Muslim community, rights of women are protected in the Hindu community, everywhere. Right? This is what I don't agree that you can go. And in any case, when you say, let us say to uniform civil, who will make the law? Of course, the majority will make the law, was appointed in parliament. If they make the law, today's majority, they may encroach into various aspects of Muslim personal law, and that will affect their rights. Right? So therefore, one has to be very, very careful. Right? Instead of trying to sort out matters, may put the country in heated trouble.
Thank you, sir.
I would also like to add, my lord is absolutely right that I have been writing it for decades, that the way forward should be piecemeal reform. Because if you bring uniform civil code in one go, the fundamentalist element in the minorities will hijack the debate and create all kinds of problems. To slowly and gradually, one by one, you bring in reform. For instance, recently, when the government raised the age of marriage for girls for 21, I again supported it. So piecemeal reform, slow reform process is better one by one. But uniform civil code in itself will not be able to curb the problem of communalism, because I have nikah and you have satpati. You don't have communalism because of that. That is not the reason of, that is not a problem of communalism. Somebody raised the question that why Vivekananda, Swamiji's Vivekananda is not used in the interpretation of Hinduism, Hindutva, etc. Yes, what he has said in Chicago, that should be the role model for us. But judges are free to pick up quotes from wherever they want. You are also right, no government. The question is, was there any regime that really distanced religion from politics? No, no government. Indira ji towards 1979-80 herself, started supporting Hindu right. I remember I had seen this posters in 1980 election with Bala Sahab Devra's picture. Baba Sahab ke naam par mohar lagegi haath par. Rajiv Gandhi in 1984 election campaign himself talked about Ram Raj. In 1989, he started his election campaign from Ayodhya. So we should not be really blaming any particular political party or any particular political leaders. All political leaders, not only in India, but all over the world, whenever they feel convenient, they use religion to polarize society to get their votes. But we as voters must see their game, that they are not for religion, they are using religion. About the terror laws, the facts speak for themselves. There have been many false cases, and if you look at the conviction rate, both under Tata and Kota, it is very low, and it definitely proves that these were false cases. Ideally, all these laws, or what are called black laws, are not good for any modern progressive country, because their definitions are wide, the burden of proof has been shifted, and confessions have been made admissible. So all these laws are in violation of classical principles of criminal justice system. I keep telling people that anyone who wants to know the classical criminal law must read Justice Patnaik's Akshardham judgment. I think that is the best reading for anyone who wants to know what a criminal law should be all about, and why criminal law must be tilted in favor of accused. Because in criminal law, state prosecutes. So it is an uneven parties. One individual is pitted against the might of the state. So state may misuse its position. Therefore, laws have been so framed that no one is unjustly punished. Therefore, presumption of innocence, narrowest possible definition of crime, prosecution having the burden to prove the case beyond reasonable doubt. If two versions of prosecution story are possible, the one which favors the accused must be taken. I think we must have a relook at our criminal justice system and should not deviate too much from the fundamental golden principles of criminal law.
Thank you. Robin, yeah.
Yes, Karthik, you have a question?
Good evening, Professor Mustafa, and good evening, Justice Patnaik. I'm Karthik. I'm from a public policy student from OP Jindal University. I hope I'm audible, right?
Yeah, you are.
Yes, you are.
So first of all, Justice Patnaik, it was really an insightful session, and Professor Mustafa, I'd like to tell you that we at the hostel we are really excited to listen to you, because just last week we heard you in our political philosophy class. Our professor made us hear you about the NDTV interview on the triple talaq. So all our roommates are also here, and we were really excited to see you all energetic on this issue. My question is to you only, Professor Mustafa. You mentioned this, with all this energy, you rightly mentioned about the wrongs in the historical writings as one of the causes for communalism. The wrongs in the historical writing, and you also ironically completely relegated the judiciary of any responsibility, but I'm not going into that. The historical writing, we talk about the Godhra riots, we talk about the Sikh riots, but we always forget to talk about the historical wrongs that was done in pre-independence phase, and that is the Mopla rebellion, sir. In the Mopla rebellion, you pick up any book, even today, you pick up any book, and there is hardly a mention that what really happened in that rebellion. It was the first region that declared itself independent and under the caliphate, and the role of our father of our nation in that, the comments and the hostility that father of our nation showed, that also is in sync with the points that you mentioned, like how British first gave preference to Hindus, so the Muslim felt insecure about not getting the government jobs. So that is all in sync with that. So why we don't talk about the issue when in the pre-independence as well? Take the wholesome view. And
No, Karthik, they are talked about. Definitely, if you look at post 1857, there is a systematic British policy, because they realized that even though Mughal regime was exploitative of peasants, but still the Indian masses saw Mughal Emperor Bahadur Shah Zafar as their own. They saw British as aliens, and therefore they tried to divide these two communities. And therefore, post 1850, you will see that systematically these seeds of communalism were sown.
thank you.
Mr. Sir, can I take your leave?
Sir, I have a question, if you permit.
I have to go.
Just one question. Just 1 minute. Sorry, sir. My question is simple. Assuming that the pace of communal hatred remains the same, with the state not doing anything, what will India will be in 2030?
It will be a sad day if the kind of hatred which WhatsApp groups are spreading, if each one of us, rather than loving each other, hate each other, then of course we are going to make mess of our country. But that will be a very, very sad day.
बहुत बहुत शुक्रिया आपको.
Thank you, sir. Sorry to your start time is your start time. Have a nice
sir.
Khuda Hafiz.
Thank you so much, sir. Yeah. So should I wrap up the session?
No, Praveen, any more questions? We'll take one.
There is a question. Yeah, there's a question from Shreya Mehta. Do you think the judgment given by the Karnataka High Court in the hijab case has embarked a sense of communalism in the country?
Justice Patnaik, please.
Justice Patnaik.
See, my reaction to it is, so far as hijab not being a basic essential feature of religion, right, that may be correct, right, but they have not properly dealt with the other aspects, the right to freedom of peaceful expression, 19(1)(a), right, whether it affects Article 51, personal liberty, they have not dealt with properly. I have read the judgment. These aspects the court should have dealt with a lot of sensitivity, right? And my personal reaction is, I think Supreme Court let's go. No matter not Supreme Court take it up, but these aspects have not been very wisely and properly held. Writing only logic and very good reasoning, intellectual reasoning, theoretical reasoning, quoting is not a erudite judgment does not make good judgment, in my opinion. Right? A judgment which really does the purpose and arrests a particular problem in the country which is taking place is an effective and correct judgment. That is what the courts are. Right? Academicians can write their erudite judgments, right? But the courts must sort out issues when the state is failing. I give an example. Yoda Akbar. Remember Yoda Akbar? Yoda Akbar case. When I was Chief Justice in Madhya Pradesh, the Madhya Pradesh government banned Yoda Akbar. in Madhya Pradesh. The matter first came to single judge. And the single judge he just admitted the matter, did not stay. He came up with an appeal to me, sitting some of the judge, a division bench. I immediately granted stay and said, all right, state government, why are you mandated to explain? They explained, they showed a government order which says, because if Jodha Akbar is shown the public in Madhya Pradesh, there may be public order. I said, this form, this opinion must have found some material. Please show us the material. They produce some material. And is this the material on which you can ban? You are affecting the right under Article 19(1)(a). So I immediately paused the notification. Right? And the government was arguing there will be pure, there will be public order, there will be so and so. Nothing happened. Not one incident happened. And Jodha Akbar was finished. So that. So it all depends. This is not writing a very, very erudite judgment, all kinds of reasoning, citing Western thought, citing Western judgment, not do. You are sitting in India, and you are watching India, you are sitting in Karnataka. When you are sitting in Karnataka, you must say, yes, it may not be a part of essential practice of Muslim religion. But there are other aspects. Kindly go into it. If you go into the other aspects, I have seen the other aspects of the judgment, they are not problem. They are writing only erudite, citing American judgment, this judgment, that judgment. Those judgments don't apply to Hindu Muslims in India. I am very sorry to say how they have applied.
Now the floor is open. Any question if you have, anyone has a...
One more, just one more. We'll have one more and then Karthik can submit. From the youngsters, please. Sir, we have a large number of students from law schools.
Yes, they came in with good questions.
Yeah.
So we have posted certain questions in the chat box.
You can read your question.
You can just read out two more you can take, Praveen, and then we.
I think there is a question from Aditi Kashyap. Sir, hate speech can be considered as the 9th point of communal rights. Don't you think that the legislation fails in curtailing such speeches as they are made in the guise of freedom of speech and expression?
Wonderful.
And a kind of related question is, what is the difference in the pattern between... No, sorry, it's a please go ahead with the first question. This is like
what comes to court is when the legislature of the state government or the central government acts, issues an order. The court finds out whether they are trying to curb freedom of speech and expression. Right? And invariably, the tendency of the legislature and the state governments or the central government is to curb the freedom of speech. Some form or the other. As I said, they fail. Though it's their duty to ensure that they fail. For various reasons. Maybe for political reasons, they fail. Rather, they do the opposite thing. They do something on account of which rights break. Right. It is for the courts to enforce freedom of speech. Why? Because it's part of Article 19(1)(a) and under Article 32 and 220, the High Court, the Supreme Court and the High Court have to enforce it. Right? So when they try to curb it, the courts have to test it. And the Supreme Court has said it time and again I have myself considered that when it comes to freedom of speech and expression, give widest latitude to freedom of speech and expression. Widest. The state has got the power under Article 19(6) to regulate this in the interest of public order, contempt of court, secure the country. So you test that state's power, whether they should have the power, right, to regulate this, and the courts decide it. So to think that the state government will curb all these sentiments is very difficult. If, let us say, if it is Kerala, they will stop the Hindus from doing something. Right? If it is some other state where the Hindus are and majority of the political party also support that, they will try to stop the other minorities from doing something. So, you don't expect, they work on political compulsions. They work on political compulsions. But the courts have to see when they pass an order, that is the primary power. The legislature or parliament has the primary power. Or the central government or the state government have the primary power to do something in that field. They have got the power to administer and to make the laws. But ultimately, it is a constitution. They will see whether this right is encroaching on 91A, no speech and expression, or religious freedom under 25. They will test it. Thank you.
So last question for the day. This is question from Astha Ranjan. Question is, don't you think that most of the terror related laws are nowadays targeted towards a community? What can be the potential solution?
Yes, you see, the problem is terrorism. Right. And terrorism form, maybe for any form, terrorism has to be controlled. There is no doubt about it. Right. But while controlling terrorism, we must ensure that the innocent people are not punished. If you confer more and more power on the armed forces, on the police, on the government, there is danger of abuse. I was posted in the Northeast. I was posted in Guwahati. Now, Armed Forces Special Powers Act, do that. It is there all over the place. And army officers have got the power to arrest, take action, and hand over to the civilian police. Hand over to civilian police within 24 hours. I have noticed what amount of crime sometimes some of the armed forces do all kinds of crimes. Because that power, the term is power. More power you go to give to a human being who cannot exercise restraint, he is likely to abuse it. Right? That is why the constitutional checks are there. He has to be put into the magistrate. I'll give you an example. Terror law. Quota Act, they applied in the Kerala case. You see, that Quota Act was challenged in the Supreme Court. Giving too much of powers to the police. It will target the minorities. It will target various people. But there are certain protections built in. And the protection are before, unless they are built in protections, the court will strike it down. Right? As otherwise Article 21, Article 22, Article 20. Right? So Article 20, Article 21. So what is the protection? You see, solely based on the confession, somebody may be convicted for terror act. This is the provision of the Act. It's I think section 22. And I told you, Mr. Banzara recorded some confession and they were punished. We found they were innocent. We said, what we found, there are the provisions is, before he goes to the police officer for recording confession, he has to appear before a magistrate. Magistrate will check up whether he has got some any injury, when he is being forced to do it, when he is in coercion. Then he will go to the police officer for recording. Then after the confession is recorded, that vertical of a person accused has to again come to the magistrate to find out whether the police officer who is recording confession has given him thrashing or tortured him. Why? Because the confession has to be voluntary. Without the confession which is voluntary, right, no conviction can be. And we found that the magistrate had not checked up in these things. While going, he had not checked up how much of beating or thrashing or any physical injury. While coming out, he had not checked up. We said the confession is not voluntary, right, and struck it down. So ultimately, the terror laws have some protections. If they don't have any protection, court will strike down the law itself. And if they have protections, like the one I mentioned, right, if they are not followed, the court will acquit the officers, acquit the accused persons. They cannot be convicted fully or innocent. Is that clear? Yes.
With your permission, Praveen, can I ask this is Patnaik one question?
Sure, sir. Please.
Sir, it is a slightly mischievous question.
Yes, that's
right. Since cricket is in the air, and I thought I'll just let me bowl a googly to a very learned judge. You mentioned that about the importance of judges being secular. This was one of the major themes of your discourse. Now most of the speakers, particularly Faizan Mustafa, has mentioned how most of the political parties are far from being secular, when it comes to garnering votes or winning at the hustlings. It's not limited to any particular party. So given this kind of non-secular character of the political parties, do you think that the new collegium system is a more improved system in bringing out more secular judges, or we do not really have any real litmus test to ensure that real secular judges are brought to the bench? This is not to cast aspersions on the judges. Since you mentioned this aspect
Don't bother about that. I have been very critical of the conference system myself. Right. And you have to read my article published in the National Law University, Delhi, when that famous judgment in NJC Act case, NJC judgment, they struck down. Yes. I said, no, that should not have struck down.
Absolutely.
Right. Because there was some tests, some measures, right? They should not have struck down. And they have reserved the powers to themselves. I said only 2 persons, 2 eminent persons were included in the NJC. They should have been struck down. Because those 2 eminent persons may be having religious biases, may not be having constitutional values.
Yes.
Right. And may be of any ideology. Right. And may not be sticking to constitutional values. 3 judges were there, 2 eminent persons, law minister. Law minister, I said, has to be there because it's part of the government. Right. But 2 eminent persons, just strike them out and demand this. Right. And please ensure that any other person who will believes in all the constitutional rules. And that would ensure that the judges who are selected are marked by the recent judgments, right? Whether they have constitutional values. For your information, even the new format that is there for appointment of judges, Chief Justice fills it up in the High Court, which I also filled up. I found he has to say what this candidate who is being recommended, does he have faith in constitutional values?
Oh, wonderful, sir.
There's a provision. But ultimately, it all will come out in a judgment. I am now writing a book which is going to be published. One chapter is on collegium system. Very critical. Very critical. Right. And I am saying that you follow voting. The UK, Right? Commonwealth Reforms Act, Constitutional Reforms Act, 2005. In that Reforms Act, UK, which you know, where Parliament is sovereign, Parliament is supreme, they don't have a constitution. They have a constitutional reform. And that say that we have to judge, we have to have judges who are independent and follow the rule of law. And they have had now a judicial commission system by which they are appointing from the highest court to the lower court. They must have independent thinking, independent from the government, must believe in the rule of law. And British rule of law, you know, Dicey and all that, what they mean. They believe. And they believe in democracy. They must have a, so we must find persons who are not merely knowledgeable in law, persons who really are secular in their behavior, right, and ensure that the National Commission recommends and the President appoints. President may refer it back once, but when the Commission again recommends, reiterates, the President has to appoint. Otherwise, the government will not appoint anyone who is not up to their own values. Their sense of values are different. Each government which will come in central government who makes the final appointment, their values will be different. You follow? Secular, non-secular, everything will depend on that. Right? So there has to be an impartial body selecting the right persons.
Absolutely, sir.
That should be this. This is my view.
Thank you, sir. Karthik.
Thank you, Professor Mishra. So first of all, we are way past the time that was estimated. So thank you so much, Justice Patnaik, for being so patient with us. We could go on hearing a lot, but the restraint of time has to be there. Lord Hayward, the then Chief Justice of England, in a case in 1924, laid out a famous dictum: justice must not only be done, but must also be seen to be done. The Jodha Akbar judgment, or the cases, the other two cases highlighted by Justice Patnaik, falls exactly in this line. And the topic that we chose, if we actually align this judgment, our system in accordance with this, the solution can be not very far, but near. The summarization of this episode can be engulfed in this quote as well, but the detailed summarization can take a lot more time. Having said that, I'll just like to thank the panelists. Professor Mustafa has already left, but thank you so much, Justice Patnaik, for your most valuable time, and thank you a lot to the audience who engaged in such an invigorating session. The one last point that I would like to say, which is of our group, the point on which, the foundation on which communalism thrives on, is binaries, and we at Beyond the Binaries seek for a solution in the grays. Ending on that note, we'll continue our search for grays in the next episodes as we come along. Thank you so much, everyone, and thank you so much, Justice Patnaik, again, for engaging with us, the youngsters and the learned and the learners. We all have got plenty of food for thought from the discussions that you brought in. Thank you so much.
Thank you, sir. Thank you. Thank you, sir.